I just want to give what is the history. Bail or jail in protest. Take a look at this. In the Anna Hazare movement 2011, protesters were charged with preventive detention, sedition and rioting, but they were all released on bail without formal charges. During the Nirbhaya case, authorities filed cases such as rioting and assault on police, but the detainees were immediately bailed out and the focus shifted to the criminal trial. In the JNU sedition controversy case, charges including sedition, criminal conspiracy, unlawful assembly were put in. Several accused only received interim bail after weeks or months. Jat Reservation Agitation 2016 saw charges of rioting, sedition, arson, promoting enmity. Many cases were later withdrawn. Most protesters were granted bail and some served short term. During the CAA protests against sedition, rioting to conspiracy, and of course UAPA was also put in because they were rioting. Now in this case, remember, there are difference. Even farmers' protests, we had sedition, rioting, conspiracy being put in. I want to understand Tanveer Ahmed Mir. The point being made by Zayed Zafar Islam in particular is that this case attracts sedition, that this should be seen as an anti-national act. Do you believe that this falls in any way within sedition?
Well, not at all. You really want to take your imagination to altogetherly a different orbit. That's your personal choice. But I would definitely second Mr. Azad that when in a robust, what is an example of a robust democracy? Even if there are foreign dignitaries, foreign participants, when they see that this is a country where even on such occasions, a protest is sustained, it enhances certainly the image, which is the image all over the world. But coming back to the whiplash of the cops, the manifestation of a malafide criminal case is infliction of 196 on its own. When Rajdeep, you raked up this issue that on a peaceful protest, certainly people taking out t-shirts and protesting about certain things legitimately without any element of violence, nobody is pelting stones, nobody is burning anything down, then the cops first have to be the judge of the cause themselves. I agree with the BJP spokesperson to a certain extent that why did the judge grant remand? Well, the judge was not able to do or to contemplate the matter in its proper perspective. Well, that doesn't mean that the judge is right.
No, but then...
Right?
No, it may not mean that the judge is right, but the government will say, look, we are following the rule of law, that the police have gone to the court, they've got a remand. Well, what else is the...
That is a matter of fact, Rajdeep. Now, I am reminded of a very famous judgment written by the Supreme Court in 1989, called as Rangarajan versus Babu Ramji, as the gentleman then was. And when it came to interpretation of any kind of reasonable restrictions in terms of any action, penal action or otherwise, what Supreme Court said irrefragably that the power and the fundamental right for your expression of speech must prevail. Everything else should be subservient unless and until there is not violence in the whole act. Now, the present...
Okay, I've heard your point. Sir, I've heard your point. You're saying that reasonable restrictions, you'll have to show an act of violence or promoting incitement to violence, none of which